I put on recording. Okay. Read the first question. This is the November 2023 criminal paper, whereby I have discussed question number 1 to 4 in my previous session. And the YouTube session, the YouTube video had been loaded in my personal channel. Interested party can have a look. Okay. We will start with question 5. I'll first read out the question, and I hope you do have a CPC with you. This is a very important statute for you. Okay. So the questions sound like this. Halim Beg has been convicted by Session Court Gua Musang. Can you all read? My slide can read. Okay. Gua Musang Kelantan of an offense under Section 372A of Penal Code. He was sentenced to 3 years imprisonment and 2 strokes of whipping and a fine of 20,000. Okay, let me just put a few remarks first. Okay, 20,000, Okay. And in default of the fine, to a sentence of 9 months imprisonment. Okay. So the defense counsel, Mr. Sri Lawan, representing Halim Beg, made an application to Session Court Judge Wan Sabrina for a stay of execution of the sentence pending appeal, okay, against the said conviction and sentenced to High Court of Kota Baru. The said application was rejected by Session Court Judge without giving reasons. Okay, so now you have to assume the role as the defense counsel. Okay, advise Halim Beg on the following matters based on the provisions of criminal code and relevant authorities. Okay, question A is like this. Okay, since the application for a stay of executions of the sentence was rejected by Session Court Judge, what would be the next step to be taken, and what are the legal principles applicable to support such step? So you are given a good marks, 10 marks to explain. Okay. Stay of execution. There are actually two parts of this question. First, what are the procedural requirement to enable this application to happen? And second, what are the grounds? What are the supporting legal principles behind this granting of stay of execution? Okay, so how do you answer this sort of question? Is that first, you must identify which section, which law. Okay, whenever you answer a question, first you go to statute or law. Okay, that one is number one, Then only you cite case law. Because case law is only showing you how the section is being applied by the court. How do we use it? The most important one is section, please. Okay. My answer is like this. Since the session court judge, Puan Sabrina, rejected the applications for the stay of execution of the sentence without providing reasons, so the next step, you have to answer straight to the point, will be apply to the High Court for a stay of execution pending the appeal. Okay, you all understand why is that so, right? Because at the moment of conviction, okay, hukuman sudah dijatuhkan ke atas Halim Beg, isn't it? By right, the first person or the court of first instance that the defense lawyer should ask for a stay. That means to say, don't execute first, don't imprison my client first, is session court judge. Since session court judge is not in our favor, she rejected our applications. So that means we have to go for appellate jurisdiction. From session court, we have to go to High Court Kota Baru. Okay. So our specific reference for this particular application is section 311, your appeal, okay, as well as section 57 of Court of Judicature. Whenever you see applications in superior courts, take for example, High Court, Court of Appeal, or Federal Court, this one, procedural rules or the power vested given to the court to grant certain application is all inside Court of Judicature Act. Whereby if you have magistrate, session court, your subordinate court, the power will always derive from your SCA, subordinate court. Okay, so these are the source of power. And CPC is the procedural power. Okay, I hope I make you enlighten a bit. Okay, so these two section collectively give the effects to the meaning that an appeal, okay, for example, you're not happy with the uh, sentence as well as the conviction. You're applying for appeal. It doesn't mean that your client, the Halim Bat, did not need to go to prison. Actually need. Okay, appeal does not automatically stay the execution of sentence, except for what? Except for corporal punishment. Corporal punishment means hukuman physical. That means you can a person, you whip a person. That one automatically stay. And one more is sentence, death sentence, mandatory death sentence, open appeal will be automatically stay. Other than that, imprisonment, fine, all that is not automatically stay. Okay. But nevertheless, this is not a harsh rule. That means to say the court has jurisdiction or discretion to stay the execution based on, uh, I mean, if there are justifications or there are good reasons, then the court can allow the granting of stay of execution. So this is what we are going to argue next. Okay. So how do we argue? When you talk about this, what we call stay of execution pending appeal. Okay. And this is, you have to seek a distinction. First is whether your clients have been convicted or not. Okay. If it is convicted, then the case law or the principles in this Re Quan Wai Yip is referred. If the client is acquitted, for example, release, okay, dibebaskan dan dilepaskan, for example, but the prosecution appeal, okay, the stay of execution is governed by Wee Sui Xiang. Okay, very important to distinguish based on the outcome of the client, the court of first instance. So in this particular case, we are going to apply the principles of Ri Guan Wai Yi here. So what are the factors that may be prayed by Halim's law defense counsel to the court in order to get the stay of execution? Okay, first is of course the gravity of the offense. Okay, second is the length of imprisonment, and also what is the gap for the appeal to be heard. Okay, number three is any difficult points of law. Number four is whether the accused is a repeated offender or is a first offender. And number five is the risk of accused committing further offenses, okay, while on bail. And number six is whether security imposed will ensure the accused attendance to the court. Okay. Eventually, stay of execution is also another form of bail. That means to say the person, the convicted person, is being released temporarily from the enforcement of the what we call the judgment by the court, so that they enjoy transient freedom. Okay, so you must understand that. And there is always an issue of the accused or the convicted person. They know their case is not very strong and they are going to face the imprisonment or whipping very soon. They know they are not going to, they are unlikely to be succeed in their appeal case, so they'll run away, they'll abscond. So this is also another consideration. Okay. And after citing your what we call your legal principle, you have to apply this based on current sentence that uh being held against Alim. Okay, so you must always make out the facts were given to you for a reason. It's not just there for fun. Okay, so he was actually sentenced to 3 years imprisonment, two strokes of whipping, and fine of 20,000. And in default, you have to go to prison for 9 months if you cannot pay. So according to the authorities here, whipping is automatically stay. So you can rely on the specific proviso, section 311 CPC, as well as section 57, okay, to make out, and also one case of men's and others against PP. And second thing, the fine. I told you the fine is not automatically stay, isn't it? Usually fine must be paid. This is based on Xin Yong Chang against PP. But however, you must distinguish this case, okay, this Halim's case from Xin Yong Chang's case. Because Xin Yong Chang case, pay is the only punishment. That's why it cannot be stayed. But whereby in Halim Bat's case, it's more on a hybrid punishment. He got fined, he got whipping, and as well as then he got this custodial punishment, the imprisonment. Therefore, Halim's case, whenever you ask for a stay of execution, usually the fine will be stay along with other sentences. Because at the end of the day, the court has a lot of cases. They don't want to confuse themselves. Suddenly, this fine, if you successfully appeal, they have to refund you back, isn't it? So they don't want this kind of thing happen. Okay? And imprisonment, and this is a custodial sentence or custodial punishment, usually will refer to the principles laid down in Wan Yip here. Okay. Okay. So what about the procedure? Okay. The procedure is whenever you have to file what we call a section 311 appeal, it should be filed to the High Court by notice of motion supported by affidavit. Okay. Notice usul lah. This one is notice usul disokong dengan affidavit. Okay. Detailing the grounds for the stay and as well as you must lay down what are the special circumstances, okay, that you want to pray for this kind of stay. And subsequently, there will be a hearing by High Court, okay, whereby both defense counsel and the prosecution can present their submission or these arguments regarding to the stay of execution. Okay, so as a conclusion here, as Halim's defense counsel, the aforesaid information shall be conveyed to him. Okay, but you have to make up something, because after you have cited the case of Wan Yip, and then you said the length of imprisonment, the attitude, all that, uh, uh, will they repeat the what we call the offense during bail time? All that will be the consideration of the judge, isn't it? So you have to roughly make out what actually these Halims had committed. If you can know what is this penal code, that one will outshine your peers. That is person living or trading in prostitution. That means to say he's a pimp. Okay? He just you know trading on introduce clients to prostitute, GR, all that. So Halims must display with special circumstances for to get execution, stay of execution for his case. I will put it this way, lah. Put it this way. Halim will have a very slim chance to get a stay of execution, PP against some cutting. Okay. Reason being is because usually those people that trade like a drug dealer, like this sort of trading in prostitution, their career is that one. So if you release them, there's a high tendency for them to repeat the offense during the bail pending appeal. That's why I will put it this way lah. I will ask my client to mentally prepare. I can help you, but your chance is very slim. So this is your conclusion based on whatever you have argued here. Okay. And second question, they test you what is the time required to file notice of appeal and petition of appeal. Very simple. Okay, you can refer to your section 307 subrule 1 CPC. That is within 14 days from the time of judgment, sentence, or order being passed. Okay, that means to say once the session court judge told that, okay, Halim Bad sudah disabitkan kesalahan, lepas tu jatuh hukum that time, onwards 14 days. You must file within this period one notice of appeal. We call it notice rayuat. Okay, I'll show you the example later on. Okay, and petition of appeal. Petition of appeal, you have to file within 14 days the copies of grounds of decision. That means to say, whenever you want to appeal, usually the court work in such a way, when a person or accused is being convicted by a particular judge, if there is no appeal, the judge need not to furnish the court with grounds of decision. That means to say they don't have to give alasan penghakiman. Okay, very important. But when somebody appeal, be it the accused or the prosecution appeal, then the judge will have no choice but to write the alasan penghakiman. So the time period for you to file the petition of appeal is 14 days after you get the copies of alasan penghakiman. That is your grounds of decision. Okay. Another thing that you must get is this one, notes of evidence. Notes of evidence actually refer to nota keterangan. That means during the trial, what happened? The prosecution witness one cross-examined by defense, what they said exactly. Okay, setuju kan dengan saya kamu tiada dalam tempat kejadian pada itu? Jawapan tidak. Something like that. They will list down, it's like a transcription from what you say during the trial into words. Is a very lengthy type of document style. Okay, so why do you need this? These two? Because criminal justice got two. Number one is substantive justice. That means justice based on the case merits. Okay, you get what I'm trying to say. Second thing is procedural justice. That means to say whether the procedural rules have been well observed during the trial or not. Sometimes the judge keep on interfering, stepping down into the arena of the debate, siding the prosecution, etc. Then you cannot even cross-examine the witness. So you can rely on notes of evidence to make out your view based on procedural justice part. Okay, so these two things depends whichever you got it last. If you got your notes of proceeding very late, That means the time start counting after you get the notes of evidence, something like that. Okay. So this is pursuant to your section 307 sub-rule 4 as well as section 307 sub-rule 5 of CPC. You must cite this specific proviso. Okay, this is just to enlighten you what is going to happen. Okay, you must, after the 14 days, whenever the decision has been given by the judge, file a notice of appeal. Okay, so notice of appeal, you have to give one copy to the subordinate court and also give one copy to the high court, as well as you have to serve one copy to PP lah, because they need to know whether you are intended to appeal or not. Then you have to request for notes of proceeding or what we call as notes of evidence, the one nota keterangan, what happened during the trial. Okay, it's a transcribed version of what happened during the trial. And then the alasan hakiman, the judgment, grounds of decision. The judge will write why he's siding prosecution, why he's not siding the defense. Okay, inside you can make out whether the judge had been make an error or not. Okay, in laws or in facts. Okay, and then subsequently you file a petition of appeal. Petition of appeal is that uh what what actually went wrong? What do you think as a defense counsel? What is your reason of this appeal? Okay, you have to state inside the petition of appeal. Later I show you lah. And then you have to file a record of appeal. That is your bundle of documents, whatever your evidence, everything lah. You have to file as a record of appeal. Then subsequently, after a few case management, the court will hear the appeal. So this is the complete appellate process. Okay. So next, you are being tested on what we call briefly, what will be the content of notice of appeal and petition of appeal, which have to be filed to enable the learned High Court judge to arrive at an appropriate decision. Okay, you highlight big, what is the content, apakah isi kandungan, okay, of your notice usul and also your petition rayuan. Okay, so notice of appeal, again, I already repeat myself many times, cite section. Okay, please cite the relevant section. Okay, okay. So inside one notice of appeal, I better show you what is the notice of appeal so you can memorize better. So this is one example of notice rayuan. Okay, actually a lot of technical things, you must cite the what is the title of this action. Okay, this is standard format lah. Usually we still use the Tanah Melayu dash Malaya Negeri Johor. So this is the Johor Bahru case. Okay, what case number is that? And then who are the accused? Who are the appellant? Who is the Rayu? Okay, this is the OKT lah. Lawan, Dawat Raya, and the name. Okay, what is the nombor banduan? Because usually for you to find the appeal, the accused is in the log one, is in probably penjara, what we call the Ulucho or that Simpang Renggam. You have to go lah, and then you have to get the thumbprint. Okay, so what section? Okay, what hukuman first? Okay, what case number first? Dihukum bila, disabit kesalahan apa, lepas tu dijatuhkan dengan hukuman apa. This is the example. And then you have to briefly, okay, briefly, you are arguing, you're not happy with the sentence, the conviction or the sentence. Okay. In this case, you see, memohon kepada Yang Arif agar hukuman penjara dikurangkan. He never asked for quitter, isn't it? He never asked to overturn the decision or the judgment. That means conviction is still conviction. Cuma hukuman tu mungkin 6 tahun jadi 2 tahun. This is your rayuan. Okay. And then you must have the signature lah. Usually we practice as such that we ask the Brayu, the convict, to thumbprint. Okay, so this is briefly what should be the content, okay, of your notice rayuan. Appellant details, judgment, grounds, okay, and signature or thumbprint. Okay, so this is real life practice lah. That's why I told you. And what about petition of appeal? Okay, petition of appeal, again, first rule, you must cite section. This is governed under your section 307, subrule 4 to 6 of CPC, and you have a very specific form to follow, form 51. 51. Okay, form 51. So I will show you two examples. Okay, you all can see, isn't it? This is notice of, this is petition of appeal. Okay, the same person, okay, you have to include what is the title of the case, okay, and you have to name who is the appellant, who is the accused lah. Okay, which section, okay, and then jatuh hukuman apa? You see or not? 6 tahun penjara, okay, and then satu sebatang rotan, all that, okay, and then what is your grounds to ask for reduction of judgment, what we call the sentence must be reduced, and subsequently you end with date and signature and all that. So this is a simple form of petition of appeal, whereby some of the cases, okay, some of the cases you still have the title. Unlike a civil procedure, sometimes I notice that uh, the procedural rules is not so strict in criminal appeal or criminal process, okay, as compared to civil. Civil, a lot of things are really tedious. Okay, so petition, rayuan, you see, okay, tidak berpuas hati dengan hukuman atas alasan. You see or not? This one is saying that the judge had been tersilap di sisi undang-undang. That means they have made errors lah. Okay, and terkilaf, you see? Huh. So this is how you argue and how you state down your reason. What is your reason to appeal? So this is lebih kurang lah. I mean, what is it? Okay, you can see the title, one is Tanah Melayu dash Melayu, the other one is Dalam Mahkamah Tinggi, isn't it? Both are acceptable. Both are acceptable. But by right, the right format is actually based on Form 51 lah. Form 51 only stated the isi kandungan only. So the title, I have not listened to my seniors saying that they got rejected lah because of wrong title. That's why I told you the criminal requirements for all the forms to be standardized is less stringent as compared to civil action. Okay. So we go to, I'll answer your question later, because it will be easier for me to put all the question at the end of the session. Okay, we will go to this question number 6. Okay, pretty easy question. Mr. Anas, a deputy public prosecutor who recently joined prosecutorial services in the Attorney General's chambers, Putrajaya, wishes to know from you the law regulating the prosecution of an accused in criminal case regarding one, open court proceedings, and second, in-camera proceedings. So you are required to explain to Mr. Anas, who had just recently joined to become a DPP. Okay, so how do you answer this? Number one, of course, you have to cite which section. Penting ni, okay? Don't simply go and write according to your um knowledge, it doesn't work that way, okay? So open court proceedings is actually inside your section 7, whereby the court proceedings should usually and generally be open to public. That means the reporters can go, the victims the families of the victim can go, or any public student also can go, no problem. Okay, this is to ensure transparency and accountability in the judicial process. The rationale is that public access to court proceedings helps to maintain public confidence in the legal system. Okay, so public can have supervisory power. Okay, that means to say, of course, no video recording, no photograph is allowed, but you can go and see for yourself. And similarly, Section 101 of your Subordinate Courts Act also enforce this principle. The court is a public and open place whereby the public will have access to. Okay. So again, the purpose of open court is to have open justice lah. Public and media, reporters lah, can go. Okay. There should not be what we call, according to Li Bun Tuan here, there should not be any obstacles lah to prevent public from attending a trial. Okay, but this is of course subject to exception. When you have a general law, sometimes general law are being too flexible. Some of the time, you need something that is your exceptions lah, to restrict this general law. Okay, so whereby you have your in-camera proceedings. So this is one of the exception to open court rule. Okay. That means to say the court can actually order the proceedings to be held privately. That means between the defense, prosecution, the personal involved, for example, the IO, the victim, okay, without public access. Party cannot enter. Okay, the the bailiff will stop them from entering the room. Okay, so whenever you have this sort of issues, okay, you see or not? The exception here is that the court will only allow a proceeding to be held in camera if it is expedient in the interest of justice. Okay, that means whenever the justice required to do so, public safety or other sufficient reason. Okay, so another one, you have Section 15 of Court of Judicature Act. Okay, so this one High Court lah. Usually rape case, sexual offences or military cases involving OSA, the Official Secret Act. Sometimes they will put in camera that to preserve the secrecy or some sort of confidential information to be leak out to the public. And one more thing, Child's Act also, okay, under Section 12 of Subrule 3 of your Child Act 2001, the trial of the minor, those who is less than 18 years old, they are not open to public generally. And in fact, if those the so-called child criminal, the children criminals, they are also not so strictly follow the ordinary court system and procedural rules during the cross-examination. Usually the prosecution is not so harsh. Okay, so this is to protect the interest and privacy of the minor involved. as you all know, any children that commit the offense, at the end of the day, their case will be only cited as TP against A, TP against X, PP against Z, like this. They will not cite like this, PP against Chi Huiping. Take for example, I'm a child. They will not cite your full name one. Okay, so this is to protect lah and hopefully rehabilitate this the convicted to be a better person. They still have a long way to go, isn't it? So in conclusion, Mr. Anas is advised that it is essential to highlight that while the general principles favor open court proceeding to ensure transparency, so this is a well-known dictum by Lord Herward, justice must not only be done, but must also be seen to be done. So this one you can quote at the end of your conclusion to make the examiner slightly impressed. Okay. So nevertheless, there are statutory provision allowing for in-camera proceedings to protect sensitive interests, maintain public safety, and ensure justice. Okay, so this is briefly about open court as well as in-camera proceeding. Quite straightforward, this question. Okay. Now you come to question B, 6B. The proviso to subsection 399 subrule 1 of CPC provides that in any case in which the public prosecutor intends to give in evidence such report, he shall deliver a copy to it to accuse not less than 10 clear days before the commencement of the trial. The said report is generally referred to as a report of an expert witness. Okay. This is section 399 CPC expert reports rule. Okay. Having served the chemist report on the accused person within the time stipulated, the prosecution now wants to call upon the chemist to give oral testimony in the court as well. So, your role now is to advise Judge Susanna New whether the chemist could still give oral evidence when the chemist report had been served on the accused before the trial begin. Very high marks, 15 marks. So as a judge, your role becomes very critical. You cannot just cite one, section 399, you cite all the 399, then you finish it. Cannot like that. Okay, you have to be balancing what are the reasoning behind the section. Okay, I will show you what is actually section 399 chemist report or whatever the laporan kimia lah. Okay, usually whenever we have a case, take for example case drug case lah, case data DDA, usually the police will seize packet of serbuk putih, take for example. Berat kasar mungkin 500 gram. Then they'll be sent, those drugs will be sent to chemist department, Jabatan Kimia Malaysia, to process it, to analyze what is the real component of the drugs, and then what is the berat bersih, what is the net weight of that particular drugs. And this one, the police will give you, the chemist will sign and then give you one report. Okay, in this case, for example, they have 2.37 gram heroin and 1.05 gram monoacetyl morphine. Because some drugs, they rojak it, to make the addict person when they take it, they feel very high, It's a mixture of the so-called ecstasy, this sort of uh, feeling. Okay, get high, get high. So not necessarily one drugs, one content, So this is section 399 chemist report. So the question put forward to you is when you have this chemist report, the chemist Take, for example, in this case, Asmira needs to come forward to court to further affirm this, what she had done. I mean, to give testimony as to what should have been done, what's the result of this test, and what are the process. Is it necessary or not? So as a judge, you have to be, like I said, critical. So Judge Susanna New is advised in affirmative. Lah. First, you have to give your view. In general, yes, the chemist can still give oral evidence even though the chemist report has been served on the accused within the stipulated time. Okay, then you give your comprehensive advice. So, how comprehensive is it? Okay, this is based on my opinion. Okay, so Section 399 Rule 1 CPC. So, PP can give this Jabatan Kimia report, the expert report, to the accused not less than 10 clear days before the trial commence. So the said report automatically becomes a documentary evidence, which is not taught by hearsay. Okay, I hope you do understand what I'm trying to say. Because any documents, if it is not presented or the maker is not there to verify the content of this document, it will be a documentary hearsay, kabar angin. Sebab orang yang membuat dokumen tersebut tidak hadir ke mahkamah untuk memberi keterangan. Itu saja. Okay? Hearsay. But this one, 399, allows document to be delivered to the accused read it, provided it is 10 clear days, then it is no longer a hearsay. Even though the chemist did not give evidence in court, the court will accept it. Okay? So as a general rule, can still give oral. Okay, the purpose of serving the report is to give the accused notice of this evidence and opportunity to prepare it. But it does not preclude, preclude or prevent the prosecution from adducing oral evidence from the expert. So you can refer to PP against Pamanaban here. Okay. So relevancy of chemist oral testimony. If the chemist is being called to give evidence, what kind of evidence you are looking at? Anyone know if the chemist come to court to give evidence, what kind of evidence is it? Yes, very good. Expert opinion evidence. Okay, very important. First thing first, whenever a person is asked to give evidence, first decide on relevancy because the court will only accept evidence based on facts in issue or relevant facts. These two only, If your evidence is outside the scope of the relevancy, the court will reject it. So, chemist oral report is a oral testimony, is actually an opinion evidence fall under section 45 and 51 of Evidence Act. Because chemists themselves is expert, remember, expert. Okay. Uh, so this is relevant. Okay. So it helps to enforce the what we call the court's ability to allow the chemist to testify orally to explain the basis of findings in the report. Okay. So where is the source of authority whereby the Susanna, you have to advise Susanna as thoroughly, isn't it? What gave her the power to do so? Isn't it? You have to decide. Now PP already tender chemist report. They apply to court chemist. What power in your hand to give rights to allow PP to do so? So you use section 136, whereby once the court satisfies this evidence is relevant, then you can admit it. You can call apa nama, chemist to come. Okay, so this is section 136. And furthermore, if the chemist comes to give oral evidence, for example, in PP against Parmanaban, the chemist report itself is about the DNA evidence, you know. This case involved the murder of one very famous cosmetic businesswoman, Sosila Wati. So uh, there are a lot of 4 or 5 co-accused. They murder the person, Sosila Wati, and her lawyer as well as one person. So DNA evidence becomes a substantive evidence, you know. So how does it being passed and all that? So it is so important to decide on the decision of the case. So chemist is called in this case. Okay. So uh it will enhance the reliability and credibility of the said evidence. And the court has the discretion, under your CPC section 425 to summon, examine any person as a witness at any stage it deems the evidence essential for the just decision of the case. So you use this tool to help Susanna. Okay. This implies even the chemist report is already submitted, the court can still call the chemist to testify if the oral testimony is essential. Okay. Like I have told you, you have to talk about why you have to analyze that why the chemist should not be called as well. So you must try hard to understand why we have this section 399. Why is that so? Why we have this documentary hearsay exception specifically codified in the CPC? Okay, so your argument is at different perspective. Okay, Judge Susanna New is also advised that the rationale behind Section 399 is multifaceted. First, it helps efficiency in legal proceeding by saving the time for court. All parties involved with this, what we call streamlining the process of presenting expert witness, making the trials less cumbersome. Okay, if everyone needs to call expert, and then you will assume a lot of time will be spent to arrange for the chemist to come. Okay, this is considering the busy schedule of the experts. Chemist department, kinda, they have 1,000 chemists. Usually they are around 10, 20 chemists. But here and there, they have to run the whole Peninsular Malaysia. So the case cannot finish on time. Okay. And thirdly, it ensures fairness and transparency because the accused had been provided with chemist report 10 days before trial. So the defense counsel can go through page by page. And somehow if the defense feel like they want to call the chemist to verify, they can make application. So this process strike a delicate balance between the interest of the accused as well as the time and cost issues. And fourthly, it balances the interest of both parties to enable efficient presentation of expert evidence while safeguarding the accused's right to a fair trial. Okay. Lastly, it also promotes legal consistency because now you have Section 399. So the chemist report will no longer be caught by hearsay, you know. So the defense cannot use it because what? The chemist never comes, so this is hearsay, should not be admitted by court. Therefore, it is a ground to challenge the judicial decision. Okay, so you have to balance it. So after you have argued all these different angle, what Judge Susanna must do is to balance the necessity. Okay, must balance the necessity of calling the chemist to give oral testimony against the efficiency and fairness objectives embedded in Section 399 CPC. Okay, if the court determines that the oral testimony is essential, okay, to talk about the chain of evidence to enhance the credibility, reliability, okay, to address the points raised by the defense, or take for example, this is DNA evidence, which is substantive evidence of this case cannot be just excluded with one piece of paper just to report like that. So chemists should come. So in making her decision, Judge Susanna, in conclusion, should consider the relevancy and necessity factors, fairness to accuse, as well as judicial efficiency. By weighing these considerations, Judge Susanna New can ensure that her decision aligns with the overarching goals of the Criminal Procedure Code as well as your Evidence Act, thereby fostering a fair, efficient, and transparent judicial process in deciding whether to call chemists to give oral evidence. Okay? Because you are a judge here. So that's why you have to analyze both sides. That's why marks a lot, 15 marks. Okay. 15 marks here. Okay? When you see the question is too simple, it's, it's always not simple. It's always not simple. Okay. Last question. 7A. Song Lap was charged with an offense of criminal breach of trust, the section 409 of Penal Code at Session Court in Mua. Okay. Before the commencement of the trial, Song Lap applied to High Court by way of notice of motion. Again, this is notice also to strike out the charge against him on the ground that the charge against him disclosed an offense unknown in law. The High Court dismissed his application. He appealed to High Court. He appealed to Court of Appeal, and his appeal was heard and dismissed. Now you see, advised Song Lap whether he could appeal to Federal Court. 15 marks. Okay, this question is not about appeal, This question is about whether Song Lap is entitled to make an interlocutory application about a preliminary issue. Okay, the preliminary issue is that the charge is defective. That means something wrong with the charge. Not happy, but the trial has not been proceeded in a session court yet. But whereby the defense already go to High Court, said that, look, High Court judge, we have a charge in session court more, but then somehow or other, the charge itself is defective. Therefore, I'm asking you to dispose this preliminary issue. Strike out the charge. Okay, so this is the issue. And High Court not succeed. Go to Court of Appeal. Now the question is whether Song Lap can appeal to Federal Court. Okay. So this is the tricky part. If you have not heard of these cases before, you better don't do this question. You'll get your question mostly wrong. Okay. I will draw an analogy from the case of Mat Zubair against public prosecutor. Based on the information provided, Song Lap cannot appeal his case to federal court. Okay, no doubt, in our system, we have two tiers of appeal. By right, if you carefully, the case of striking out, the application to strike out is originating from High Court, isn't it? So High Court go to Court of Appeal, one tier. By right, you still have a second chance to go to Federal Court, provided you have a serious question of law. Okay? But whereby in this case, it said no. Why is it so? The case itself analyzed the jurisdiction of Federal Court, whereby they use section 87 of CJA, okay, to determine the jurisdiction of federal court, whereby subsection 1 said that the federal court shall have jurisdiction to hear and determine any appeal from any decision of the Court of Appeal in its appellate jurisdiction in respect of any criminal matter decided by High Court in its original jurisdiction. Okay. Subject to any rules regulating the proceedings of the federal court in respect of appeals from the Court of Appeal. Okay. See, second, notice of appeal by PP shall be signed by PP, SG, or any officer, the alter ego of PP. And subsection 3, an appeal may lie on a question of facts or a question of law or on a question of mixed facts and mixed fact and law. Okay, you see, now you have to decide. Actually, the court of first instance for Song Lap's case is actually at session court more, isn't it? The case shall be first trial for whatever the conviction for the offense that he has got in session court more. If the decision given by session court, then they have one chance, one tier to appeal to High Court. If High Court they still lose the case, then the final appeal shall be Court of Appeal and finish it. Okay, so this is what they argue as affirmed in Munawar Ahmad Anis against PP. Okay, in Ahmad Zubair, the federal court actually rejected the applications to be heard in federal court because they said that High Court is not the court of first instance. High Court is the place to decide the preliminary issue raised by the defense counsel. It is not the court of first instance. Okay. Second consideration is as of the nature of the decision itself. Okay. The nature of the decision is actually on applications of defense counsel, the court will strike out the charge by ordering the NAA. Okay, so inside this Ahmad Zubair against PP, okay, Song Lap's appeal is related to preliminary issue of whether the charge against him was defective. The High Court and Court of Appeal's decision on this issue are interlocutory. Okay, that means to say it's just like your discovery, your what we call your interrogatory application. This one actually does not really dispose the rights of the party, you know. The court, without hearing the whole case, can only order what? Can only order the NAA. Discharge not amounting to acquittal. They cannot issue perintah DAA, dilepaskan dan dibebaskan. If it is DAA, dilepaskan dan dibebaskan, then there will be issue of atrophis acquit. That means the whole case cannot go one more time or being retried again. Now, because the application is just to strike out the charge, therefore it does not actually dispose the rights of the party yet. Okay, so this is referring to the decision. Okay, they use section 3 of CJA. Okay, such rulings by right is not appealable in nature. So this is pursuant to case of Datuk Sri Anwar Ibrahim. Whenever you quote Datuk Sri Ibrahim and Datuk Sri Anwar Ibrahim, Datuk Sri Muhammad Najib, usually are based on very important and challenging issues of law. You hardly get wrong. You get me? Those people, they hire good lawyers. So a lot of constitutional issues, a lot of question of law. Okay, but it's just that you want to avoid your problems. Probably you can uh, you don't quote the year. You don't quote the year, just quote the name. At least you're half right. Okay. And third is about the abuse of court process. So the federal court in reference findings strongly discourage appeals on preliminary issues as they can lead to significant delays in criminal proceedings. So you see, Song Lap's repeated attempts, first he applied in High Court, tak jadi. Go to the appeal, pun tak jadi. You see or not, what happened to the case in Session Court? There will be a penggantungan proceeding. That means they stay the whole proceeding just to wait for the decision of High Court. Tak jadi. Mungkin sudah setahun. Go to the appeal, lagi setahun. So 2 years, the case never has any progress in session court judge. This is the strategies used by uh, good lawyers, good lawyers. Okay, by famous person. I mean, of course, they must be able to pay, isn't it? Then you use your intelligence to help to delay that case. Hmm. Okay. The inherent power of the superior court in administration of justice shall be used sparingly. Okay. So usually to strike out the case is actually the it's not the power of the court, to decide what to charge and who to charge and what offense to charge. Is the PP power, enshrined in the Article 145 Rule 3 of Federal Constitution. Okay, so actually when courts strike out the charge, they use inherent power. Inherent powers is that the power vested in superior court and it is not written anywhere. Okay, that means the court itself is a place of justice, is a place of equity. There are some powers that the court can exercise based on facts to facts basis. They need not to refer to written law. Okay, something like that. In dealing with striking out charges, the court will not conveniently apply its inherent power against Datuk Sri Anwar Ibrahim. Okay. So what is about the laws or authorities? Reliance on case of Kappa Singh against PP, okay, is misplaced. A lot of politicians especially, they use Kappa Singh against PP. This is a case whereby the late Kappa Singh had some sort of offense. He organized an assembly gathering without the written approval or consent from the police, therefore infringing a certain section under Police Act lah. Okay, so in this case, actually the court is not bound to follow this passing because CJA 1998 made amendment, towards the scope of appellable decision. Okay, this is again section 3 lah. They made a distinction between appellable decision. There are three: judgment, sentence, order. Those could be appealed. Whereby ruling yang bukan apa sentence, bukan decision, bukan order, all that is free, so-called interlocutory rulings. They will not consider appeal. Appeal is not an option lah. Okay. So they also consider the power to strike out the charge is actually vested in PP. Okay, Article 145 and Section 376. Okay, to institute, conduct, or discontinue any criminal proceeding. So the power PP. Okay. So normally the court will be reluctant to assume the role of AG. Okay, most of the time, the AG will decide if they wish to amend or drop the charge and pray for the NAA. Okay. So conclusion, in light of the above, it is unlikely the federal court will entertain Song Lap's appeal. His remedy will be to raise the issues of the charge validity during the trial as session court, and if convict, appeal, and the final decision of court of appeal. That means to say he still has to proceed lah. Ah, session court tak jadi. Okay, after the merits lah, hearing the merits of the case. Okay, the case shall end at court of appeal. Okay, it should not go to federal court. So this is the full argument of this factual scenario. Okay. 7B. Based on the information supplied by one Miss Ayn, Inspector Ramu investigated Tom Cruise, who suspect to have committed a spate of robberies along Jalan Richmond, Kuala Lumpur. Tom Cruise has been charged with robbery under Section 392 Penal Code. So during the trial, Tom Cruise defense counsel, Mr. Singtam Garang, raised a preliminary objection stating that due to non-existence of written police report against Tom Cruise, the police had no right to investigate and Tom Cruise was entitled to an acquittal. Mr. Garang argued that the information provided that led to the arrest of Tom Cruise did not fulfill the requirement of CPC, and the victims themselves should lodge a police report in order to qualify the police to investigate. So discuss the validity of grounds raised by Tom Cruise defense counsel during his trial. 10 marks. Okay. First thing first, don't be too excited, argue step by step. Okay. So this case, to assess the what we call the validity of this objection, we need to examine the relevant legal provisions and principles. So police report, usually we refer to FIR lah, the first information report. Okay. So this is under your section 107 of CPC, and whereby the information, okay, given regards to commission of cognizable offense will be given orally to a police officer, okay, at the reception counter and subsequently be reduced in writing and read to the informer, and the informer need to sign it. This is section 107. Okay, whereby section 110, okay, because they are challenging police, ada kuasa nak menyiasat case robbery. Is it true? See, section 110, okay, provides that if this is a seizable offense, take for example, section 392 robbery, okay, seizable offense usually refer to those offense carry more than 3 years imprisonment. Clearly, section 392 is a form of seizable offense. They do not need any order to investigate from PP. Very important. They can straight away the sergeant or the sergeant above lah. Usually the sergeant, major sergeant, or the instructor. Okay, they will straight away investigate. Okay, so the police have actually duties to prevent and investigate crimes. And the absence of formal report actually does not negate the police rights to investigate. Okay, so Emperor against Khwaja Nazir Ahmad. Okay. And police investigations normally, most of the case shall be based on FIR, but sometimes it could come from their own intelligence. That means to say they have informer. Sometimes the drug lords, the case that we have taken, they will have somebody follow them for a few days on you before they are caught. Okay, so there are some network of intelligence by the CID, the Crime Investigation Department, the narcotics, the cyber crimes also have their intelligence around. Okay. So CPC actually does not mandate only victims of crime can lodge reports. Information from any credible source can trigger a police investigation. So Inspector Ramu investigation is based on Misiron information is actually legit lah. Okay. The police are authorized to act on any incredible information regarding to the commission of a crime, whether the information is in writing or oral. Okay. Uh, while the written reports are formal means to documents the complaint, their absence actually does not invalidate the subsequent investigation if the information again is a credible one. So in practice, usually, let's say they receive a call from Miss Iron. Subsequently, to facilitate the charge against the accused, usually they will ask Iron to come to station to lodge a formal police report to the arrest. Okay, it could happen. Mm. And you have case law to support what you say. PP against Fong Qi Leong. The case implies that if let's say FIR is reduced to writing, but it somehow is not being adduced during the trial, can there be Section 114G adverse inference to be held against PP? Okay, usually FIR FIR is trigger, it's just a start for the case to be investigated. This is not a substantive evidence. Substantive evidence, take for example a murder. Substantive evidence here will be the corpse of the deceased. Okay, mayat orang mati, that one substantive. Blood stain weapon, that one substantive. But just a FIR, it does not actually help too much in the case. That one is collateral evidence. Okay, so you cannot invoke Section 114G just because PP does not provide FIR during the trial. You cannot say, oh, you cast a doubt blah, because they never produced the FIR. So therefore, you have a reasonable doubt in your case. Cannot. Okay. Like I said to you, this is not a substantive evidence, but collateral evidence only corroborate or contradict the testimony of the witness. Okay, PP against Balachandran. So who can lodge FIR? Anyone, any aggrieved person, friends, relative, or even police officers sometimes who conduct the raid. Okay, they can lodge the police report. Reason being, they want to have some sort of contemporaneous evidence. Contemporaneous evidence means bukti pada ketika itu. Because after a while, let's say for example now I arrest a person that a snatch thief. So the police, usually the one that arrests, they will make their reports also. Later on, they can recall their memories. If not, during the cross-examination by the defense, they'll forget a lot of details, making the case very weak for PP. You get me? Contohnya, saya cadangkan kepada kamu pada hari itu, awak nampak OKT pakai baju hijau. Betul atau salah? Betul. And then second question, you are tricking them. Sebenarnya OKT pakai baju merah hari itu. Finish. So you actually don't see the OKT. Was the one that snatched the purse of a person. Something like that. That's why they make a contemporaneous police report. So in the submission, what you want to say, Tom Cruise is not entitled to an acquittal on the grounds to challenge the validity of his FIR, and the trial shall be proceed based on substantive evidence and the merits of the case. The police duty to investigate is fundamentally tied to the receipt of credible information about criminal activity, which can lawfully police initiate an investigation even in the absence of police report. There is no law specifically provide that victims should lodge a police report. It is likely the preliminary objection raised by the defense will be quashed by the court. Okay? Cannot lah. That means to say, you have to give a conclusive answer about what you have discussed. Eventually, because the question invites you to discuss itu siktam garang argument can be successful or not. So you say cannot. So you conclude at the end so that the examiner get a very clear picture of what you want to discuss at the end of the day. Okay, that will be last question. I turn to answer your what we call your question, and I'll pause the review.